Jacinda Ardern.
Mr. Chair, I think we need to be absolutely clear about what the Minister has and hasn't done with her amendments for this bill, because this does not simply reinstate positions that were removed and everything is back to the status quo. The current legislation allows for there to be up to 3 full-time, up to 5 part-time commissioners, and the flexibility to point around what those roles need to be. Now, of course, we've added the Disability Commissioner, the specific role. We applaud that. Obviously, that means we would then sit at 4. But what this bill does is mean that we could essentially end up with fewer commissioners than what the original Human Rights Act allowed us to have. So I want to be absolutely clear. Thank you, Minister, for your SOP number 175. We support the SOP. It was the right thing to do to reinstate those specific designations, but the bill still has not changed that the Commission will consist of the Chief Commissioner and not less than 3 and not more than 4 other commissioners. Even if they take the maximum, we will still have fewer commissioners. That is a matter of fact. And I am yet to see a rationale from this government as to why we would want to reduce the representative roles that commissioners have within the Human Rights Commission. Why would we want to reduce their capacity? They've always used their flexibility appropriately in that regard. They've sometimes used their part-time roles as a 0.3 and up to a 0.5, according to what the needs of the Commission were. But it seems suspicious to me that at the same time there have been criticisms that the Human Rights Office, the Chief Executive, is drawing a salary that required, as I understand, a special exemption from the State Services Commission. That at the same time we're drawing higher salaries for our Chief Executive, we're reducing the number of commissioners. So I'm somewhat suspicious about that. So unless the Minister can tell me that she fully exhausted all of the rationales why we wouldn't want to give the capacity to have the same number of commissioners we have now, then I will remain suspicious as to why we are doing that. And unless I hear some rationale as to why we would reduce that representation, that is one of the reasons that we have had concerns and previously had opposition to this bill. So thank you for the designations, but I still have significant suspicions. Perhaps the Minister might want to rise, and if she perhaps suggests that if this is not an issue of concern, why isn't there an SOP that at the same time as she has included the specific designations, that she's reinstating the number of commissioners that it's possible to have. It was one of the options canvassed by the regulatory impact statement. They looked at just simply retaining that flexibility. In fact, one of the whole reasons we had this bill in the first place was a complaint there was a lack of flexibility for the commissioners to be appointed. Well, now we've got a situation where the Minister rightly has said we will have a specific employment relations, we will have a specific race relations, and we'll have a specific disabilities commissioner. Actually, if you include the Chief Commissioner in there, we could end up with nothing else. Nothing else. So, Minister, I would really appreciate some rationale from you. Perhaps maybe, if not that, a commitment that any budget saved would be going back into representative work and not just higher salaries. Or an SOP on the table saying that actually there's no point reducing the number of commissioners and that you will maintain what was the status quo. So, Mr. Chair, I look forward to some response from the Minister in that regard, because it is significant. It may seem like we're just removing some flexibility, but we of course had grave concerns with taking out a designated title. So why would we not have concerns with removing the discretion in the future to appoint a commissioner in an area that becomes of substantive concern? And I've already raised an example of where down the track it would be potentially useful to have that ability from the Human Rights Commissioner. Mr. Chair, there has also been raised the issue of consultation with the Minister. Because this amendment bill, even though there is some specification within the bill as it currently, in the Act, the 1993 Act, around consultation, that's in specific reference to the Commissioner's allocation of portfolios, it reads to me. In this particular amendment bill, it's very clear. Under Part 1, 6(1)(b), it states, Commission must lead the work of the Commission in any other priority area that is designated by the Chief Commissioner, Mr Chair. And the Chief Commissioner may designate an area of work as a priority area only in accordance with the strategic direction and the general nature of activities determined by the Commission under Section 7.1 and after consultation with the Minister and other Commissioners. That reads to me that both the strategic direction and the designation of roles could be determined, therefore, with the Minister. Now, I know it's been stated that consultation means that the Commissioner can come in and inform. I've seen the word consultation used in those relationships before. And let's be really clear, because I've heard, for instance, the Law Commission, who I doubt that anyone in this House would think feels under the thumb of the government at all. And I have heard them at Select Committee say that even though they have the ability to set their own agenda in terms of the work that they do, that they know there is no point in bringing to the Minister something that will be in consultation with the Minister for their work program, something that is not within their political orbit or their political priorities. So there is a self-filtration that happens when you are required to consult. Even though it's the word consult, that means entities naturally will not bring something that they consider to be unpalatable in case it gets taken off the agenda and just dismissed. So if it is simply a matter of being informed, then call it that. Then let's be specific, that it's actually just that they have to notify the Minister. The word consult is very different to the word notify. And I have no doubt that a Human Rights Commissioner who's obliged to consult, therefore is likely to take on board the feedback that is given by that Minister when it comes to allocating any potential new Commissioner roles. Now, I thought that this amendment bill could have been a perfect chance to reflect back on the Paris Principles, which was passed by the General Assembly at the United Nations on the 20th of December 1993, which set out the status of national institutions. Basically, what should it look like when a country sets up a human rights institution? What are the really core principles to make sure you establish a proper, robust human rights institution? And it talks in the Paris Principles that a national institution shall be vested with competence. It should be given a broader mandate as possible. Now, I think that's interesting. A national institution shall be given as broad a mandate as possible, which shall be set clearly forth in a constitutional legislative text. So whilst we want to specify composition and sphere of competence, actually allowing that flexibility which we talked about in those roles, which we lose in this bill, is a core principle of the Paris Principles. It also talks about submitting to the government or on an advisory basis, either at the request of authorities or at the exercise of their own power, any human rights concerns. But all the way through, right down through, and I found particularly, Minister, the methods of operation, the framework that the national institution shall freely consider any questions falling within its competence, whether they are submitted by government or not, hear any person, address public opinion, establish working groups from among its members as necessary. All of these fundamental principles talk about the need for them to maintain that independence. And there was a prime opportunity with this review of the Act to sit back and say, are we upholding the Paris Principles to the very best of our ability? And if there is any concern that embedding principles around consultation may be misinterpreted by a commission to be more than advising or informing, then perhaps we should change our language. Perhaps we should look about the kind of language that embeds independence. And in fact, if we really were taking a first principles review, why wouldn't we set up at the same time a select committee within our parliament to review human rights on a regular basis to ensure that we are upholding those important institutions within New Zealand? It's been recommended. I think there's good grounds for it. That's the kind of first principles debate we should have been having when this amendment bill was put forward, and in fact when the Ministry of Justice in 2010 established its review in the first place. Going back and ensuring that we were trying to uphold those principles as we signed to within Paris in 1993.